police did not see him drive.
When you saw the vehicle, were you able to make out, identify the driver?
No, I mean, it was maybe a silhouette, but no.
Results indicated his BAC was 0.171.
Where is the evidence that he was the driver?
I think that what you're asking for is direct evidence that he was the driver.
I'm asking for any evidence. Let's call the Patch matter quickly. There are no motions filed in that case. Mr. Patch is appearing virtually from what looks like some sort of potential locker room. Mr. Patch, I'm going to unmute you, sir. Can you hear me?
Yes, I can. Good afternoon.
All right. Good afternoon. 25T 8835, people of the state of Colorado versus Morgan Patch.
Trevor Kennedy for the people.
Good afternoon, Mr. Kennedy. Good afternoon, Mr. Patch. How are you, sir?
I'm nervous, but okay.
All right. Fair enough. Prosecution has just endorsed an expert witness. Mr. Patch, did you receive that pleading?
Not yet. I haven't seen it.
The endorsement is for Stephanie Olafson, listed as a forensic scientist, toxicology, drug chemistry for Colorado Bureau of Investigations. We are set for pretrial readiness conference August 21st at 11 a.m. and trial on August 26th and 27th, starting at 8:30. Mr. Kennedy, anything else for the prosecution today?
Yeah, Your Honor, just a couple things. First, I will admit to the court this is the first time with regards to a extra endorsement that we've needed to try and get service to a pro se party. I've received some word from our legal assistant team. We'll get that in the mail and make that happen. The other thing I wanted to address with the court is just to see whether or not Mr. Patch has picked up any of his discovery yet.
Mr. Patch, are you in possession of your discovery?
I am. I picked up one package of discovery with CDs.
Mr. Patch, anything else for you, sir?
No, Your Honor.
All right. Sir, we're going to see you back August 21st at 11 a.m. for a pretrial readiness conference. Pretrial readiness. Is the prosecution announcing ready?
Your Honor, I'm not. I am directing the court, obviously, to the motion to continue jury trial that was filed on August 20th. I'm happy to make any further record as needed. Ms. Olafson is the CBI expert in this case. Your Honor.
Is Ms. Olafson under subpoena?
Yeah, yes, Your Honor. The subpoenas, most of the subpoenas in this case were dropped and mailed approximately between the dates of July 19th and July 20th.
And did she return her waiver?
I'm not seeing that here, Your Honor. I believe it was mailed, given they're not law enforcement.
Why did she respond for the first time this week?
I am not sure. I know that the note confirming her unavailability came from my Midwest specialist on August 17th. Yeah, Miss Olafson was emailed to accept her subpoena then.
And she responded promptly and said no.
That's correct, Your Honor.
How many times have we been in this situation with CBI?
Too many for me to count, and probably many before I was here in 301, Your Honor.
Mr. Patch, is there anything you want to say?
Not much. I was notified of the motion prior, and actually before filing, we had a quick phone conference to discuss the proceedings just to make sure I was up to date, which I did appreciate. However, given the duration of the case, we're coming up on a year for this case, and along with impacts on other items in my life, I want to make sure that I'm giving this the undivided attention it deserves. So there's no immediate conflict, but it is still stressful. It doesn't impact my end of the case a ton, other than I'd like to see us go to trial whenever possible.
All right. In order to grant the prosecution's request for continuance, the court would have to find there has been due diligence in attempting to obtain the witness. The court, based on the record that's been made, cannot find due diligence. This is, as stated by the prosecution, countless time we've been in this exact same situation with CBI in this division. The court has previously denied requests for continuances under the exact same conditions, which doesn't seem to have helped to remedy the problem. The court has gone as far as to demand CBI appear and answer for the problem. And they said they would escalate it internally to make sure things didn't happen again. That clearly hasn't happened. So prosecution's request to continue the trial is denied. Mr. Patch, are you announcing ready for trial?
Yes, Your Honor.
All right. Trial remains set to go next Wednesday at 8 a.m.
August 29th, 2025. Defendant chose to drive his vehicle after he had drinks at some local bars. When in doing so, he went off the roadway, crashed through a fence at a Starbucks, hit a bike rack, continued through and hit a sign at the neighboring bar. He then proceeded to drive back to his house. And that is where police officers contacted him. Police officers started getting calls. They got a call from a woman saying that she had heard what had happened, and as she looked over, she saw a white truck leaving the scene. And if I'm going to direct your attention, if I could, to this area right here. There's an item on the ground that's going to be pretty significant here in a second. There's a little closer up. It's a license plate. Colorado license plate, and you can tell there's no stickers for expiration. That looks like the front plate to a vehicle. So that's the scene. That's what the police showed up to. The police did not see him drive. They did not see anybody hit this stuff. You're gonna have testimony from other witnesses. There's gonna be some circumstantial evidence that you're gonna rely on, like that license plate. So they run the license plate, and they pull up an address. They're gonna go respond to this address to see if the car is there and see if they can contact you. So officers respond to the address. And in the park or in the driveway of the address, they find this white truck, missing a front license plate. It's got damage on the bumpers. So what we have so far, we have people that heard an accident look over just in time to see a white truck leaving the scene. Now, the license plate left at the scene that corresponds to that vehicle. And the police show up to the defendant's home. Well, this is the blood test from the defendant. The number that is underlined there is a .171. But when they asked him to give this blood, he refused. He did not want them to see what that number was going to be. So the charges today that we have are driving under the influence and leaving the scene of an accident with unattended property damage. And later on, we're going to go through those elements. And we're going to explain in detail sort of what each of them are and how we met them. But what's important is as you listen to the evidence, what I'm saying is not the evidence. The evidence is only going to come from whoever's sitting in that chair. And then at the end, put it all together and kind of decide what you think happened. And decide if what I have shown you gets you to a point where I have removed all reasonable doubt that the defendant got behind the vehicle while he was drunk, crashed into some property, left the scene, and returned home where he was not. That after this is all complete, I believe I will have met my burden, and I'm going to ask you to find him guilty. Thank you very much.
Thank you, Mr. Sloan. Mr. Patch, would you like to make an opening statement?
No, Your Honor.
All right. Mr. Sloan, feel free to inquire.
Yes, Your Honor. Good morning, Ms. Berger. Thank you for coming today.
Yes.
Would you mind just introducing yourself, spell your last name for the record?
My name is Megan Berger, Berger, and I've lived in Inglewood at the time of the incident.
Okay, and then what's your relationship to the case today?
That I called 911
And why did you call 911?
because I heard very clearly a very big ongoing crash that didn't seem to even stop. It wasn't like your typical, bam, something hit. It just kind of kept going on and on. And I called 911 without even knowing what happened because just knew it couldn't be good. I mean, it could have been an airplane crashing or whatever it was.
From where you were at, could you determine the direction the sound was coming from?
Not exactly. I mean, I knew it was really close. And so I was walking around. I looked to the south side when I walked out my front door, and I didn't hear anything. And then I looked over to the left, didn't quite see or hear anything, but I kept walking. I was in the middle of the street and I was scared because I didn't know what happened. I mean, I probably iterated that at some point with the dispatcher. And then it was very clear once I saw the fence, 2 trees taken out, but there was a mess. And then if you want to know the rest, I can tell it now, or you can continue to ask me, but
Go ahead, tell
okay.
the story. as you remember.
So I'm looking, I'm like, wow, this is like a really big crash, but I didn't see any other cars. I didn't hear anything. And I was walking back towards my house, and out like a street up comes a white truck, and there's just parts dragging. And I mean, I could hear it before I saw it. And then I saw it still on the phone. And I said, there it is. He's making a left on to Logan. So it was obvious to me that was the vehicle that, was in, that did that, because it just, was destroyed.
And when you saw the vehicle, were you able to make out, identify the driver
No.
and anything about the driver whatsoever?
No, I mean, it was maybe a silhouette but no.
Oh, yeah, thank you. Now, the vehicle itself, what sort of what you can remember, could you describe the vehicle in as much detail as possible?
It was a white pickup truck. I think it was a Dodge Ram, only because I've been in the auto industry. And it had a trailer hitch on it. I'm fairly certain.
Do you recognize what I just placed in front of you?
Yes.
Do you know what that is?
Yep.
How do you know what that is?
Because I lived there.
If you could, would you mind stepping down and over by that television? I'm going to give you a stick there. If you could just, to the best of your knowledge, point to where you were and where the vehicle was when you saw it.
That's where I was. When I was on the phone with 911, I walked out into the middle of the street. There was a red light right here. And so I heard everything, came out here. I came out, watched him drive all the way up here to the light. I was on the phone with the dispatcher. Like I said, he's making a left with Logan right now. And that was about the end of my participation in it.
No further questions, Your Honor.
Mr. Patch, do you have any questions for Ms. Berger?
No, Your Honor.
Good afternoon, Officer Sanchez. Could you please state and spell your last name for the record? State your full name and spell your last for the record.
Yeah, Ryan Sanchez, Sanchez.
And where are you currently employed?
Inglewood Police Department.
Were you employed there on August 29th, 2025?
I was.
What is your role with the Inglewood Police Department?
Patrol Division.
How long have you been a patrol officer with Inglewood?
With Inglewood for 2 years.
And did you work anywhere before that as a police officer?
I worked at Evans Police Department for 3 years before that.
And what was the initial call that you received?
The initial call was from a reporting party named Megan. She lived in the area, said that she lived in the area of Broadway and Quincy. Called in, said she's heard a loud crash, thought it was a car accident. She also stated that she saw a white truck speeding away from the area.
Thank you. Did you respond to that call?
I did, yes.
And when you got there, what did you find?
Initially, when we arrived in the area, we didn't have an exact location, so we conducted a canvas. I think it was Sergeant Casper was the first one to find a downed metal fence on the south side of the Starbucks that used to be located at Broadway and Quincy, right across the street from the reporting party's house.
Your Honor, people move to admit exhibits 1 through 5.
Any objection?
No objections.
1 through 5 are admitted.
Your Honor, permission to publish exhibit 1.
Granted.
And if you need to step down from the witness stand, just let me know. But do you recognize, or can you explain what this is?
Yeah, so the road you're looking at is Quincy. Okay, that's an east and west running street.
And walk up and kind of, I guess describe what we're looking at here. I think that's where you were headed
Yeah.
with your testimony there.
Yeah.
Do you want a pointer?
No, I'm pretty tall.
Okay.
Okay. This is the Starbucks. This is where that down fence is going to be, if I'm not mistaken. Here we go back.
You can go back, please. Thank you.
Mr. Sloan, make sure that no unadmitted exhibits are displayed.
Understood, Your Honor. I apologize.
Thank you.
Did you find a note, for example?
No.
Anything with anyone's contact information?
No.
Any insurance information?
No.
Thank you. Did anything stand out to you about that truck?
A few things. Yeah, we were able to confirm that the license plate that we found on scene was the front license plate, because the white pickup truck was missing the front license plate. The rear license plate that was still on the pickup truck matched the front license plate that we had found on scene. There was also damage, I believe, to the front driver's side and front passenger side corners of the suspect vehicle, of which I think one of them had green paint transfer. The defendant was placed in a holding cell, I believe, at the Inglewood Police Department while applied for, or I'm sorry, the defendant was advised of Colorado Express consent.
Real quick, if you don't mind, could you explain what is Colorado Express consent?
Yeah, so at that point, I informed the defendant that he was under arrest for DUI. By the act of driving in the state of Colorado, you have to consent to a chemical test of your blood or breath. At that point, I was giving him the option to do either a blood test or a breath test. He refused both.
So at that point, once he's refused, what did you do next?
I applied for a raider warrant or a blood draw warrant to seize his blood.
Were you ultimately able to get that warrant?
I was, yes.
And so I want to back up a little bit here. What was the determining factor to investigate it as a DUI?
I think there's a multitude of factors to why we investigated it as a DUI. It wasn't one specific incident. I know that there's information in other officers' reports that.
I would have stopped your officer.
Yeah.
I just want to go on what you have firsthand knowledge of. So what did you see and what did you do? It's okay. I can move on for just one moment. One thing I definitely want to cover off, the individual in question on that day. Do you see them in this courtroom?
I do, yes.
If you could point to them and identify them by an article of clothing, please.
Yeah, right there with the blue suit and maroon tie.
Your Honor, let the record reflect that the witness has identified the defendant. And I'm going to ask a more direct question. The decision to make the initial arrest, was it based on other officers' observations of the suspect?
Yes, that played a part in it, yes.
Okay, thank you. And as we scroll down in the results and opinions section, can you explain what we're looking at?
Yeah, so that's going to be basically what was tested. The ethanol right there is the alcohol that was tested. The tab directly to the right of that is the result. So
what was the result number?
Results indicated his BAC was 0.171.
Okay, thank you very much. And I'm done with the technology, Your Honor. In your interactions at the jail from the time that you got there, started the whole express consent process, did you have any indication of intoxication from the defendant?
Just confirm, he wasn't at the jail. He was at the Inglewood Police Department holding cell.
Oh, thank you for that clarification.
And I don't remember specifically anything that I saw or smelt from that night.
Thank you for that. Your Honor, I have no further questions for this witness.
All right. Thank you. Mr. Patch, would you like to ask any questions to Officer Sanchez?
Yes, Your Honor.
All right. Go ahead.
Good afternoon, Officer Sanchez. Just a couple of questions. I wanted to go back to the your arrival at the defendant, my home, at the night of the incident, you stated that you personally inspected the vehicle upon arriving at the residence.
Correct, yes.
Okay. Aside from any damages to the vehicle as they were presented and displayed, was there anything else that you noticed, possibly with the interior of the car? Any, say, like containers of alcohol or anything that would seemed odd to you?
No.
No. Did you personally interview anyone else at the residence that night?
Yes.
Do you remember who those individuals were?
I believe her name was Sarah Perez.
And if you want to, if of course it pleases the court, re-review the incident report from that night. But you said that you interviewed one individual named Sarah.
Correct, yes.
Okay. No further questions.
Any redirect?
Briefly, Your Honor.
Go ahead.
When you were inspecting the vehicle, did you touch it?
I don't remember if I touched it or another officer touched it.
Okay. No further questions, Your Honor.
Recross.
No, Your Honor.
Is Officer Sanchez under subpoena?
He is, Your Honor.
Can he be released?
He may be released, Your Honor.
Any objection?
No, Your Honor.
All right, officer, thank you for being here. You're released from your subpoena, free to go. Thank you.
Thank you.
You're welcome. Next witness.
No further witnesses from the prosecution, Your Honor. The prosecution rests at this time.
All right, ladies and gentlemen of the jury, when the prosecution rests, the court always takes a brief recess to take up some legal issues. Thank you. Please be seated. Any motions or anything for the record for the prosecution?
Nothing from the prosecution, Your Honor.
Mr. Patch, anything for you?
No, Your Honor.
Sir, I need to advise you regarding your right to testify or not testify. If you do have the right to testify in this case, if you want to testify, no one can prevent you from doing so. If you testify, the prosecution may cross-examine you. And if you have any prior felony convictions, the prosecutor can ask you about those, thereby disclosing them to the jury. Mr. Sloan, does Mr. Patch have any prior felony convictions?
No, Your Honor.
Have you made a decision whether to testify or not?
Yes, Your Honor. I would like to testify.
All right. My next question was, what is your decision? Sounds like your decision is to testify. Sir, is it your free and voluntary decision to testify?
Yes, Your Honor. One question. For the evidence that has already been presented for this case, I do intend to present that to the jury again for clarity for my testimony. However, I don't have any digital copies.
Oftentimes in bigger cases, I'll say district court felony cases, they'll have a paralegal with them and they'll be running the slideshow. So it might be that these attorneys need their computers while you're testifying, but Mr. Sloan?
I don't mind displaying them, Your Honor.
All right. All right. Why don't we take about 5 minutes and we'll come back, bring the jury in. Mr. Patch, I'll ask you, would you like to call your first witness? And you can say, yes, I will call myself or I'll testify. Does that work?
That works.
Okay. Thank you. All right. The court's going to recall 2060-8835, People of the State of Colorado versus Morgan Patch. The parties are all here. The jury is still in the back. I apologize for the delay. One of the reasons for the delay is I was reviewing Criminal Rule of Procedure 29A. That is a rule of procedure that governs motions for judgment of acquittal. The reason I reviewed that is primarily because throughout the testimony, I did not hear a single person say Mr. Patch was the driver or even the registered owner of the vehicle. I heard that he was at the address of the registered address of the vehicle, that he was contacted, that he was arrested, that he had a blood test done, and that he arguably refused to consent. Ms. Berger said she could not see who it was, at best a silhouette. I didn't hear any statements that Mr. Patch said he was driving and something else happened, like a medical emergency or anything like that. Rule 29 of the Rules of Criminal Procedure permit the court, either upon motion of a party or on its own motion, to find that it's not appropriate to give the case to the jury because the evidence presented is not sufficient and substantial to present, because there's no reasonable possibility a jury could find beyond a reasonable doubt that the defendant committed the offense. Because I am bringing this up, Mr. Sloan, you're absolutely entitled to respond and direct me to evidence if you believe there is evidence there that Mr. Patch was the driver.
One moment, Your Honor.
Sure. I'm going to have Mr. Gilbertson hand Mr. Patch Rule 29 as well as two cases. The first is Bennett 515 Pacific 2nd 466. I'm sorry for not citing those originally. I didn't print copies for the prosecution since you have access to Westlaw.
Your Honor, can I be heard now?
Yes.
Okay, Your Honor. In regard to whether he was or was not the driver, we have evidence of his vehicle being at the scene. His license plate was found there. They went to the house or from the registered vehicle. He was at that house. That is his vehicle. You have he was there at the place when they showed up, and that's where he was taken into custody. And the light, or when you view all the evidence in light most favorable to the non-moving party, which in this case is the prosecution, I do believe that there's plenty of evidence that a reasonable juror could determine that he was the driver of that vehicle.
Mr. Sloan, you said that Mr. Patch is the registered owner. Who testified to that?
Correction, Your Honor. Thank you. So when they followed the registration of that vehicle back to the address of the registered owner, Mr. Patch was the one that was at the house. And that's where they contacted him. And so you are correct, Your Honor. There was no evidence presented that he himself is the registered owner.
So your argument is a corresponding license plate was found at the scene.
And then they go to the house that it's registered to. That vehicle.
I'm gonna run through it just to make sure I've understood your entire argument. So it's the corresponding license plate found at the scene, and then on a white truck, which vaguely matches the description, although not the same make and model, a white truck pickup described by Ms. Berger. The truck is there at the registered address. The truck has potentially corresponding damage. At the address the vehicle is registered at, they find Mr. Patch. I'll acknowledge he's been identified as the person they contacted and arrested that night, and the person who did the blood tests. Where's the evidence that he was the driver?
The fact that the vehicle's license plate was found at the scene. And yes, I'll give you that the eyewitness she gave a different make and model of a moving vehicle when she's terrified that's driving away from her. I'll give you that she got the make and model wrong. They can use circumstantial evidence. They can put it together for themselves if they think there's enough there. They don't necessarily need someone to say, for sure, I saw him driving that car, to be able to determine that he was the driver of that car. Sure, I'd love to have that, but we just don't have that.
Mr. Sloan, it's not at all the court's position that only people found behind the wheel can be charged or convicted of DUI. It's the fact that there is not a shred of evidence that Mr. Patch was driving at the time of the incident. Not even circumstantial. They literally followed a vehicle, not the physical vehicle itself. They followed the address in the registration to the home. They then contacted an individual who was in the home. Not the only individual in the home, an individual in the home. There is not a single piece of evidence tying Mr. Patch as either the registered owner, matching the description of a driver, seen getting out of the vehicle, or anything like that. That's the breakdown here that I'm seeing and I'm struggling with. Sounds like there's other officers involved in this case. One officer said that part of the decision to arrest Mr. Patch was based on other officers' observations. Okay. We don't have any idea what those are. They're not in evidence. Just because he was arrested doesn't mean he was the driver. Just because he refused to provide a sample doesn't mean he's the driver. Not even circumstantially.
May I respond, Your Honor? So,
This
Your
is
Honor,
the chance.
we don't need proof beyond a reasonable doubt. We don't have to prove to you beyond a reasonable doubt right now. What we have to do is we have to prove that in light most favorable to our side, that with the totality of the circumstances they could find. And I think that what you're asking for is direct evidence that he was the driver.
I'm asking for any evidence.
In Your Honor, the fact that the license plate was found at the scene led them back to the vehicle that was in his it was in the driveway, and when they got there, he was the guy that was there. That is enough. Now, it seems that you want direct evidence that he was the driver.
Any evidence, Mr. Sloan. I've asked for any evidence, direct or circumstantial, that meets the Bennett standard pursuant to Rule 29, which is whether there is sufficient and substantial evidence. I'm not asking for proof beyond a reasonable doubt. I'm not asking for clear and convincing evidence. I'm not even asking for a preponderance of the evidence. I'm asking for more than a modicum of evidence, which is what the Sprouse Court says in that case, which can be found at 983 Pacific 2nd 771. All I'm hearing is a person found at the address the vehicle was registered to was Mr. Patch. That's it. That is your argument. All of your other argument relates to the identity of the vehicle as the vehicle in question, not who the driver was. So we're not going to go back and forth. Court's finding that the evidence presented by the prosecution did not contain direct or circumstantial evidence. Court's noting the Sprouse factors or guidelines, the fourth of which indicates that a modicum of relevant evidence will not rationally support a conviction beyond a reasonable doubt. Verdicts in criminal cases cannot be based on guessing, speculation, or conjecture. That is the state of the evidence in this case. The court finds that the prosecution has failed to meet its burden to deliver the case to the jury. Court dismisses the charges against Mr. Patch. Ms. Sequin.
Yes, just for the record, Your Honor, I would note that the people are objecting to this decision, and we do intend to appeal this decision.
As is your right. Your record's made. Thank you, folks.